Hello guys, welcome to SK Legal Vlogs. Hope all are doing well. And in this vlog, I'm going to share with you on the topic of when does an individual dispute become an industrial dispute. Guys, the definitions of industrial disputes as given under section 2K of the Industrial Disputes Act 1947 may include within its ambit a dispute between a single workman and his employer, because the plural in the context will include the singular. In order to safeguard the working class in this country, the Supreme Court and indeed majority of industrial tribunals are inclined to take the view that a dispute raised by a dismissed employee, provided it is supported either by his union or in the absence of a union by a number of workmen, can become an industrial dispute. In the case of Bombay Union of Journalists versus the Hindu Bombay, where the services of the one of the person who claimed that he was full-time employee of the Hindu, that is a daily newspaper published in Madras, were terminated. The Bombay Union of Journalists raised the dispute in respect of the termination of services of that person, and it was found that out of 10 employees in the office of the Hindu, 7 were working on the administrative side and 3 on the journalism side, and out of these 3, 2 were members of the union. And in view of these facts, that the Supreme Court held that the Bombay Union of Journalists was not competent to raise the dispute, and even if it had raised, the dispute could not have become an industrial dispute. So in view of the conclusion is that on the basis of discussion we come to the conclusion that a dispute to become an industrial dispute must be at the following characteristics, such as there must be a dispute or difference, or the dispute or difference must be between a specified parties, or the dispute or difference must be connected with the specified subject matter, and the dispute or difference or reason between the specified party must relate to an industry, and the individual dispute to fall within the definition of industrial dispute must be sponsored by the trade union of the workmen, or if there is no trade union, it must be sponsored by the majority of the workmen, or it must comply with the requirement of section 2A of the act. Now we see the dispute between a dismissed employee and his employer is an industrial dispute. An individual dispute in connection with discharge, dismissal, retrenchment, or termination of services of any individual workman is an industrial dispute within the meaning of the Act by virtue of the deeming clause, that is section 2A of the Industrial Disputes Act, even if no other workman or union of workmen is a party to the dispute. So in such cases, there is no need that a considerable number of workmen must espouse that dispute, or that it must be espoused by the trade union. Thus, the position before the introduction of section 2A of the Act was that a dispute between an employer and an individual workman could not per se be an industrial dispute, but now it could become one if it was taken up by a union or a number of workmen making a common cause with the grieved individual workmen. Only then a dispute that type of may fall within the definition of industrial disputes and are to be followed under the Industrial Disputes Act. Thanks for watching this vlog and keep watching